Welcome to Canadian Justice. I'm Christine Van Geyn, and today we're discussing the recent Supreme Court decision in a case called Quebec et Senneville. The case involves a legal challenge to the mandatory minimum sentence of 1 year for the crimes of accessing and possessing child sexual abuse imagery or child pornography. This crime is a scourge on society. It fuels the abuse of children by creating a market for these images, and it re victimizes children every time these images are downloaded. Parliament rightly takes these offenses extremely seriously. The case of R and Senneville involved two separate and unrelated cases of men who pleaded guilty to the offenses of possessing or accessing hundreds of images of very young children being violently sexually abused. The men challenged the mandatory minimum of 1 year on the basis of not their own case, but on what is called a reasonable hypothetical scenario, a different set of facts that could happen and where the mandatory minimum would be grossly disproportionate. The court considered this and accepted the argument. The Supreme Court struck down the 1 year mandatory minimum on the basis that it would also apply to a scenario where a 17-year-old girl texted a nude image of herself to her 18-year-old boyfriend, who then shared it with a friend who held on to it. The friend could be subject to a 1 year mandatory minimum, and the court said that that penalty would be grossly disproportionate and violate the Charter protection against cruel and unusual punishment. How should we think about this case and others like it, and the role of reasonable hypotheticals? Here today to discuss this are two experts, Professor Stephen Penney from the University of Alberta Law School and Colton Fehr from University of Saskatchewan Law, whose work was cited by the court in the Senneville decision. Thank you both for joining me today. Colton, I'll start with you. The case has upset a lot of people. And I think if you were to ask the average Canadian, they would actually believe the punishment for these offenses should be higher. But the court here has struck down the 1 year mandatory minimum. So, how would you explain this case to people who are upset?
Well, I very much understand the upset. As you mentioned, these are vile offenses and warrant a significant period of incarceration in the vast majority of cases. But sentencing is not just about the gravity of the offense. Parliament has provided that the fundamental principle of sentencing is that the sentence is proportionate in light of both the offense's gravity and the broader blameworthiness of the individual offender. And while Parliament allows courts to place emphasis on denunciation, deterrence, and rightly so, it also requires that other sentencing principles are accounted for, such as society's interest in rehabilitating individuals to prevent future crime, and also a general emphasis on use of restraint in when considering imprisonment. So, viewed through that lens, minimum sentences can sometimes operate in a blunt manner. They give rise to problems because it's impossible to predict which type of offender will end up before the court. So the Supreme Court's thinking then is if Parliament wishes to impose a minimum, it should put some more thought into whether there are some criteria that ought to be made out with respect to the offense before a minimum sentence follows. Or alternatively, Parliament might consider adopting a broader safety valve provision for minimum sentences more generally. So, if I had one piece of advice for disgruntled citizens, it would be that they should go to their elected representatives and ask for a reply law to Senneville. Even if that's not the party you voted for, I think there
Mhm.
is a general will in the broader polity to respond to this decision.
Now, this might be the first time many people in the public have heard of courts relying on reasonable hypotheticals instead of just looking at the facts in front of them. But this isn't new. Stephen, maybe you can tell me about where this approach came from and kind of its role in Section 12, cruel and unusual punishment doctrine in particular.
Yeah, so the origin of this doctrine really goes all the way back to just a few years after the charter was enacted in a case called Smith from 1987. And that case first set out the basic principle underlying Section 12 of the charter, which is the right of all Canadians to be secure against cruel and unusual punishment. And the way the court interpreted that provision was to say, well, if Parliament wants to enact a minimum sentence, and keep in mind that's just a minimum, right? It can go much higher.
Mhm.
But as a floor, it can do that. But it won't be able to do that if applying that minimum sentence would result in a grossly disproportionate sentence, either for the offender before the court or
Or a
a reasonable
hypothetical.
hypothetical
We've got to
offender.
go to break, Stephen, but we'll continue this when we come back.